Good morning. Welcome to the meeting of the Assembly Committee on Government Affairs for the 2025 legislative session. Will the Secretary please call the roll?
Assembly members Carter, DeLong, De Silva, Edgeworth, Flanagan, Gallant, Golding, Gurr, Hunt, Jackson, Karras, Kasama, Wynn, Chair Considine.
I am present. Please mark Assemblymember Carter present when he arrives. Welcome to the audience in Carson City, those joining by video conference in Las Vegas, and those listening over the internet. I'd like to start with some housekeeping messages. Please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide a business card to the committee secretary. When you are testifying, please turn the microphone on and clearly state your name and any affiliation for the record. Turn the microphone off each time you are done speaking. If you are providing handouts, please ensure that hard copies are available for members of the public. Electronic copies should be submitted to our committee manager by 9 a.m. yesterday for the committee members. In this committee, we expect courtesy and respect in our interactions during the meeting, even if we disagree with someone else's position. I encourage committee members to ask questions and engage with the material presented. If you have any follow-up questions, please flag them for me so we can ensure we balance our time effectively during the meeting. And committee members will be using their laptops to view handouts and other documents. Please do not interpret this as a sign of disrespect or inattention. With that, let's get started. Today, we will hear two bills. First, we will hear Assembly Bill 64, which revises provisions relating to public meetings, and then Assembly Bill 125, which revises provisions relating to public bodies. I will now open the hearing on AB 64. Please come up to the table. Great to see you this morning. To present this measure, we have representatives from the Office of the Attorney General and former Assembly member. Please introduce yourself and go ahead when you're ready.
Thank you so much. For the record, Teresa Benitez Thompson, Chief of Staff to Attorney General Ford, Teresa, last name Benitez, Benitez-Thompson, Thomp, S-O-N. A pleasure to appear before one of my favorite committees in the whole wide world, Assembly Government Affairs. I do have with us Chief Rosalie Bordelev, who's going to be providing testimony and do a walkthrough of the bill for you this morning. Just wanted to start off with a couple of opening comments before I hand this over to Mrs. Rosalie Bordelev. So we're going to be talking today about the open meeting law. This is one of my most favorite chapters within NRS, and I think that we could say that it's one that is all about protecting the public in terms of public benefit, openness, and transparency in government. There are good values here. There are staples of democracy within open meeting law that protect the public's right to be able to know what decisions, laws, rules are being made about them, that public bodies have to have certain deliberations and conversations in public, and that the public have access, and that there's a level of transparency and sunshine in the actions that government takes. So at its heart, very good principles. Practically and applied, though, you can run into some tricky navigation on how you interpret openness and how you interpret transparency and how you balance that with the very difficult work that government has to do and allowing government to move at the pace that is efficient in order to move through the items that it needs to at some public hearings. So you're going to hear lots of conversation within Section 2 and Section 3 about some of the push and pull in terms of where the balance is to allow for openness and transparency, but also to make sure that we've got something in place so that governments can function and work at a decent pace. With that being said, I'm going to hand it over to Chief Bordelev.
Good morning, everyone. I'm honored to be here and appreciate the opportunity to speak with you today. My name is Rosalie Bordelev. It's R-O-S-A-L-I-E. Bordelev is B-O-R-D-E-L-O-V-E. And I'm the Chief of the Boards and Open Government Division within the Attorney General's Office. This division houses the Open Meeting Law Enforcement Unit within the AG's office, in addition to representing many state agencies governed by public bodies. Assembly Bill 64 includes revisions to NRS Chapter 241, which is Nevada's open meeting law, and in one other chapter relating to the open meeting laws application. I would like to start with a bit of an overview of Nevada's open meeting law as it stands today before describing the revisions contained in the bill. Nevada's open meeting law, or OML, was first passed in 1960 and is considered a sunshine law. Sunshine laws exist in many states and are laws requiring public disclosure of government agency meetings and records. In enacting the law, the Nevada Legislature declared that all public bodies exist to aid in the conduct of the people's business, and it is the intent of the law that their actions be taken openly and that their deliberations be conducted openly. This is the intent stated in NRS 241.010. When I conduct trainings on this law to public bodies across the state, I emphasize the importance of that provision as it guides the interpretation of the law by both our office and by the courts. Nevada courts have stated that the OML was promulgated for the public's benefit and as such should be construed in favor of openness and transparency. The OML applies to meetings of Nevada public bodies, both of which are terms defined in Chapter 241. A public body is defined in NRS 241.015 and includes any administrative, advisory, executive, or legislative body of the state or a local government consisting of 2 or more people, which expends, disperses, or is supported in whole or in part by tax revenue, or which makes collective decisions or recommendations to such a body and is created by the state constitution, a statute, regulation, city or county charter or ordinance, executive order, or formal resolution. Subcommittees of public bodies are also public bodies. The legislature is exempt from the OML, although it often follows many of the same procedural standards, such as publishing agendas, allowing public comment, and facilitating public access to meetings. The OML also only applies to a meeting of a public body, as defined in 241.015, as a quorum of the body together with deliberation or action. A quorum is generally defined as a simple majority of the public body, while deliberation is collectively to weigh, examine, reflect, or discuss upon a matter, while action is a majority vote. So the OML does not prevent all discussions by members of a public body, only those that involve a quorum. Additionally, the OML does not prevent the gathering of a quorum at a social or professional function, so long as there is no deliberation or action. The open meeting law imposes several requirements on public bodies, including the posting of a full agenda that clearly and completely describes all items to be discussed and is posted no later than 9 a.m. on the 3rd working day prior to the meeting. Meeting notices are posted to the state's notice website, which is notice.nv.gov, at the public body's principal office and the public body's website if it maintains one. The agenda outline requires public comment periods at the beginning and end of every meeting or before action items. It further requires that all supporting material be made available to the public when it is provided to members of the public body. Public bodies are also required to keep minutes of their meetings that include the substance of discussions and actions. Exceptions to the OML are few and narrow. Public bodies may hold closed sessions to consider the character, alleged misconduct, or professional competence of a person. They may also receive information from their attorney regarding potential or existing litigation involving a matter over which the public body has jurisdiction and to deliberate toward a decision outside of the agendized meeting. However, certain litigation decisions must be taken during an open meeting unless the public body has delegated that authority to its chair or chief executive. Additionally, emergency meetings are authorized in the law, but may only be used to address truly unforeseen circumstances, such as disasters or health and safety emergencies. The open meeting law requires the public have an opportunity to comment at each meeting. Reasonable limitations may be time, place, and manner restrictions. A public body can never restrict comment based on the viewpoint of the speaker. Presiding officers may limit public comment when the comments are unduly repetitious or willfully disruptive. The OML also does not prohibit the removal of a person who willfully disrupts a meeting to the extent its orderly conduct is made impractical. Any action taken in violation of the OML is void, and the Office of the Attorney General has statutory enforcement power to investigate and prosecute violations. Additionally, any person denied a right conferred by NRS Chapter 241 may sue to have the action declared void. The public does not have to rely solely on the Attorney General's office for enforcement. Criminal and civil penalties may also apply to members if the violation is knowing. The Office of the Attorney General strives to assist members of the public and public bodies in understanding and complying with this law. We provide training to bodies across the state and offer training videos on our website available to anyone. There is a Deputy Attorney General assigned to answer open meeting law questions every day. Thank you for indulging in my summary. I'm happy to take any general questions, or if the chair prefers, I can move directly to presentation of AB 64's proposed changes.
Thank you for the presentation. If we can go straight to the bill, and then we will ask all questions at the end. Thank you.
Sure, thank you. Section 1 changes the exception for attorney-client conferences with public bodies to include all legal advice and deliberations regarding that legal advice, not just advice regarding potential or existing litigation. It can be difficult at times to determine whether a topic a body is receiving advice on is potential litigation versus general legal advice. This change will allow the attorney-client exception to extend to all legal advice that would otherwise be protected by the attorney-client privilege if the client weren't a public body. Sections 2 and 3 set a minimum time limit for public comment of 3 minutes per person. They also allow for a restriction on public comment regarding contested cases as defined in the Nevada Administrative Procedures Act in order to protect the subject of the hearing's due process rights. Provisions in NRS 233B, which is the Nevada Administrative Procedures Act, as well as constitutional due process protections, prohibit adjudicators from communicating with parties or their representatives regarding issues of fact or law without notice to the other party. This protects a public body's ability to restrict public comment such that they do not receive ex parte communications outside of noticed hearings. Section 4 clarifies the meaning of the physical location requirement for contested cases and regulation hearings. It also clarifies that the requirement for virtual public comment options is limited to when there is no physical location for the meeting. Section 5 removes any special privilege for a public commenter to defame or slander another person. This does not impose any additional obligations or legal liability, but simply puts public commenters on the same legal footing regarding defamation as if they were making their statements anywhere else. And lastly, Section 6 clarifies that all provisions of the OML do not apply to proceedings relating to an investigation conducted to determine whether to proceed with disciplinary action against a licensee under Nevada's Title 54 governing professional licenses in the state. The existing language makes it unclear whether the proceedings are entirely exempt from the OML or just exempt from the agenda and notice requirements. The proceedings described in this provision is the provision in Chapter 622, occur prior to due process protections attaching, as they are preliminary investigatory proceedings. Many Title 54 boards do already have an exception from the OML for these types of investigatory committees, but for the boards that do not have a specific exemption, this would be a general one to cover those. And I'm happy to answer any questions that the committee may have.
Thank you for the presentation. Committee members, do we have any questions? Assemblymember De Silva.
Thank you, Chair. I just had a quick question for clarification. The term contested cases, can you explain what that means? Is this a debate or some kind of disagreement that parties are having? What does it mean vis-a-vis the text of this law? Thank you.
Thank you. And Rosalie Bordelove for the record. The term contested case is defined in NRS 233B. It is not just any dispute. It is specific, and I don't have the exact, I could pull it up, but the exact definition in front of me, but it's specific to due process hearings, essentially. Hearings where there may be, where a party is entitled to due process before a license is disciplined, before or revoked. It is that type of hearing. In the state vein, which is what I deal with the most, this is often professional licenses prior to there being discipline or revocation or anything, regulatory body taking an action against a license. The licensee is entitled to due process. And so that entails certain notice, appeal rights, a full hearing, the ability to defend themselves. And so which is why there's also a prohibition in 233B, and there's due process protections from the adjudicators having those ex parte communications outside. But it's when there's that due process protection, and the change in this law refers specifically to that definition in 233B.
Thank you. Our next question is from Assemblymember Karas.
Thank you, Madam Chair, and thank you for your very thorough presentation. My question is very simple. The change from 2 minutes to 3 minutes for testimony, public comment, was that a consensus from the public, or how did you arrive at that?
So the law does not currently have a specific minimum time. The law allows for reasonable time, place, and manner restrictions. The most common, and I think where we came with
I'm
3
sorry, Ms.
minutes
Bordelev,
was-
would you please state your name for the record? Thank you.
Sorry, Rosalie Bordelev for the record. I apologize. The open meeting law currently just requires a reasonable time limit. You can have reasonable limits to time. The most common time limit we see across the state is 3 minutes. And that's where we went from. We were looking to add a bright line standard so it would be more clear for chairs and for our office and enforcement, but it would be a lot more clear for public body members and others what is considered a reasonable time. 3 minutes is what we see most commonly across the state, and so that's where that number came from. If it was considered that if a lower minimum were set, many bodies that might currently give 3 minutes would probably default to whatever is said in the law as being the minimum, and so that was a consideration as well.
Thank you. Thank you, Chair.
Thank you. Our next question is from Assemblymember Hunt.
Thank you, Madam Chair, and thank you guys for your presentation. My question is sort of like what Assembly Member Karas was talking about. Basically, on the 3 minute changes that you guys was talking about, how would that affect public participation?
Thank you, Rosalie Bordelev, for the record. I can't say for sure how it will affect exactly. One change I expect to see currently, there aren't usually total caps on public comment, but on issues that are high profile where there are many commenters showing up to a meeting, we see shorter time limits often show up, sometimes 1 minute, other times. And if there are complaints, the shorter the time limit, the more likely a public body is to get a complaint. And that takes a lot of work off of them to need to then defend it, as well as determine whether they can move forward with actions they took. Our office has to look at all the facts and circumstances to determine whether any specific time limit that was set is reasonable. So putting such a time limit on per person does not prohibit public bodies from having a global time limit. And by that, I mean coming into a meeting and saying, we are going to take 3 hours of public comment. It's first come, first serve. Each person gets 3 minutes. And then at the end of 3 hours, you stop. Whether that's 3 hours or 1 hour, it's going to depend. What's reasonable depends on the meeting. It depends on how much public interest is in the issue, what the public body's ability to function, essentially. So our office, if we're receiving complaints on this, is going to have to come up with a determination as to whether or not a global time limit is reasonable. But I do expect to see more of those used if we're seeing a 3-minute per person limit. I guess, and that's, so there is a potential to have, I get,
This is,
more global time limits being set. I apologize for not having, you guys articulate with how. I do expect to maybe see that. I don't otherwise entirely know how it will affect.
for a response, Teresa Benitez Thompson for the record, through member Considine to member Hunt. So this is a question that's being asked kind of globally of the office right now. The question is being begged. You see most public bodies around a 3-minute standard. Having been a former member of this body, 3 minutes kind of was a standard, although you're exempt as a body from open meeting law. You comply with the spirit of open meeting law for as long as you can. And so we looked at what kind of the standard is and where the practice was laying in the majority is around 3 minutes. But we do see a handful of public bodies doing reduced minutes, and we get complaints about that. And when we get complaints about that, that means that those actions on that agenda are hanging in limbo while our office makes a decision about whether or not that's reasonable enough, and our decision time for deciding if that's reasonable enough and all the factors that go into that. It seems to make sense, and it seems to have the public policy conversation with you folks. Does it make more sense to have a bright line rule so that, as opposed to tying up other public bodies while we're making decisions about their public speech time limits, public comment time limits, that instead, if we all have a common understanding that we're sticking to, then we have obvious violations versus non-violations with that bright line, and less of the complaint administrative process on our end to make that decision for bodies. So it's up for, it's a public policy conversation that merits this type of conversation.
Thank you. Our next question is from Assemblymember Kasama.
Thank you, Chair. Good to see you again. My question is regarding the exemptions, and I don't know if this is for Ms. Bordala or, but under Section 5, it defines what the public body is, which is subject to the open meeting law. And then you listed the exemptions. Could you list those again? And is there one place that it's cited where the exemptions are?
Rosalie Bordelove, for the record, I guess to clarify, you're referring to Section 5 of 241.015 or Section 5 of this bill?
Section 1, NRS 241.015, Section 5.
Okay. This, and again, Rosalie Bordelove, for the record. So the change in this exemption here, currently a public body is, it's not considered a meeting if they gather as a quorum to receive advice from an attorney representing them regarding potential or existing litigation. And so they can have that meeting outside of an agendized, it can be closed session, or it could simply be a phone call that occurs with no notice, no agenda. And it's entirely permitted. Its purpose is to protect the attorney-client privilege. And currently, they are also permitted to deliberate regarding that advice that they are receiving in that closed door. I don't want to use the word meeting because it's an exception from the definition of a meeting, but in that closed door session, that group. But they can't make a decision officially. They need action to be able to make that legal decision. And that happens during a public meeting. What this change is looking to do is take out the ambiguity as to whether something is potential litigation. Because I'm sure if you guys have worked with attorneys at times, you can do the logical steps to make anything, almost anything, potential litigation. And there isn't any bright line as to say, well, you have to have the litigation threat. because you may not have a specific threat, but know that there is a real possibility of litigation surrounding something and want advice from your attorney. So the goal here was to make it a little bit easier for bodies to know when they can have this session, and also to a little more fully protect that attorney-client privilege. So this change would allow an attorney to give a public body advice that is attorney-client privileged advice regarding matters that aren't necessarily potential litigation, but it's still legal advice in those closed door sessions. But it specifies that the deliberation and discussions that occur between a quorum of the body must be limited to the legal advice, which aligns with current law regarding attorney-client privilege. When your client isn't a public body, these are all discussions that if an attorney had with a client who wasn't a public body, all of those discussions would be subject to the privilege.
Follow-up, Chair. Thank you. Yeah, I think I understood that part. What I was referencing more was overall exemptions to the open meeting law. So, for example, the legislature is exempt from that. What I was curious, and that's per the Constitution, but is there a section in code that specifically exempts what areas are exempt from open meeting law? Or is it just because they're not included in this definition of public body? I hope that is a clearer question.
Yes, Rosalie Bordelov for the record. There are various exemptions to the law for certain types of meetings or certain bodies, and they exist all over NRS. There's no one place for it. The largest place you will see it is if they don't meet that definition of a public body, then the open meeting law doesn't apply. But there are other exemptions out there. For example, I mentioned, there's a little clarification in 622 for certain Title 54 bodies, but there are other regulatory bodies that have an investigatory committee that is essentially a subcommittee of the larger regulatory body. Because the regulatory body is a public body, that subcommittee would meet the definition of a public body, but it has a special statutory exemption that says you're not subject to the OML. Another example I would give is in Chapter 288, discussions with a local government employer when it comes to labor negotiations. They can have meetings with their management representative that are entirely exempt from the OML. And so while they are a public body, this certain type of discussion that they have is exempt from the OML based on a separate statutory exemption. So there's a number of those, and I don't even have an exhaustive list, but there is not any specific, they're not all in one place in Nevada revised statutes.
Thank you. That's what I was looking for. Thank you.
Thank you. The next question is from Assemblymember Jackson.
Thank you, Chair. So I may have misheard, but after 3 hours, whoever's hosting the meeting or chairing the community meeting, they are allowed to reduce the 3 minutes, or do they just stop seeing hearings, public comments altogether?
Rosalie Bordelov for the record. There is no, that was an example. The 3 hours was an example, but the law currently permits any reasonable time, place, and manner restrictions, which could be a per person time limit, or it could be a total time limit, saying we're going to take public comment for this many hours. What that total time limit would be has a lot of factors that depend because it would need to be reasonable. With this change, they would have to give 3 minutes per speaker, but a global time limit is permissible so long as it is a reasonable limit. And so they could say, we will stop considering public comment after a certain amount of time. How much that time is would depend on the circumstances of the individual situation.
Is there currently a time limit now that's established by law that, if it goes over this certain time that they could do what you're saying?
Teresa Benitez Thompson, through Chair Constant, direct to the member, thank you, to Assembly Member Jackson. So right now, there's not a maximum time, I think is what you're saying. For example, the public body doesn't have to put a time restriction on. If it's a low agenda, things are quiet, they can just take public comment and they don't have to put restrictions on that public comment at all. What you might see is that, especially at the local level, a lot of those agendas are very heavily packed. They're pretty meaty. As you guys move through session, your agendas will become very packed and very meaty. So you do see the body start to put restrictions on either the individual speaker or the over amount of time, or speaker and overall amount of time. They would announce it at the beginning. So say, for example, if you've got a contentious issue and quite a few people, let's say hundreds of people, are going to show up to speak, some in support of a measure, some in opposition of a measure, that public body can say at the front, we're going to take 6 hours of public comment, and we're going to do 3 in support, we're going to do 3 in opposition. And so this bill does not at all put any constraints that aren't already there in terms of just it has to be reasonable. If you've got 600 people showing up and the public body says, we're taking 10 minutes of public comment, we're likely getting 600 complaints from the public regarding reasonableness for the amount of time that was given for the public to speak on that issue. So the public bodies are reasonable, they're judicious, they realize that. Chairs will realize, we've got lots of people showing up to speak. We want to hear people speak. We're elected, so we know that part of the job is hearing from the public, and we fully embrace the ability to sit through and listen to the public comments, right? So we're not making restrictions on that global amount of time. What we're proposing is saying, at a minimum, you should give each individual speaker at least 3 minutes. And the reason why we're proposing this is because as we do see more public bodies go to 1 minute, 2 minutes, or such, we're getting more complaints with the lower amount of time limits.
Thank you. Our next question is from Assemblymember Gallant.
Thank you, Chair. Good morning. Sorry, Assemblymember Jackson's question kind of spurred my question. So I know a lot of times in the law, like judges will kind of interpret the law, but then also say this is industry standard of what we see is reasonable, right? Example I'll give is like 5% is allowed to be charged for late fees of the total rent. That's how it says it in the statute. But for Section 8, the judges rule only on the tenant's portion. Right. So I'm curious, what would your body see as like a reasonable amount of time to allot for public comment? So is there an industry standard where you would say this body gave an hour or 2 hours and we would see that as reasonable, but another body might only give 30 minutes and you're saying, yeah, that's not reasonable in total?
Rosalie Bordelev, their global time limits like that aren't very common right now. So I would say there isn't an industry standard. It also would vary immensely how often the body meets, how long their agendas are, how long their meetings normally go. There's a lot of variables that could cause what is reasonable to vary a lot. The industry standard we have seen is the 3 minutes is most common as a per person limit. And that's where this came from. I have seen shorter, and there are times where shorter maybe is reasonable. But the 3 minutes is definitely the industry standard. But like I said, the larger total time limits on a public comment period aren't very common right now. We do see them on occasion, but they're definitely not common enough for me to be able to say what an industry standard would be.
Okay, thank you.
Thank you. I do have one question clarifying. As far as remote public comment goes, so people calling in, that is currently allowed when there is an in-person meeting or non-in-person meeting, and that changes, this bill changes that, or have I misunderstood?
Rosalie Bordelev for the record. So they're always permitted. Nothing ever restricts a public body's ability to have additional forms of public comment. So they always could have, video public comment and call in many different forms. But there was a change last session that added a requirement if there's no physical location that there be clearly a call-in number on the agenda. But then the later provision states that that number be announced during public comment. But the provision that says the number be announced during public comment does not limit it to when there is no physical location. And so the two provisions didn't quite, but there's no actual requirement in there that when there is a physical location for the meeting, but you may have a few members attending via virtual means, that there be virtual comment provided. It's just, and the requirement was a little confusing. So the attempt here was to mirror the agenda requirement language and say, when there is no physical location for meeting, a public body must list a call-in number for public comment on their agenda and read that number during the first public comment period.
Thank you for that clarification. So just to make sure it does not prohibit when there is a meeting, it does not prohibit public comment from calling in if listed on the agenda.
Rosalie Board of Record, correct. It doesn't, public bodies are never prohibited from having virtual public comment options for the public. It's encouraged. Many public bodies do it on a regular basis now. We always encourage it. We love to see extra, but in the law is just minimum requirements.
Thank you so much for that. And seeing no other questions from the committee, I want to thank you very much for your presentation. And we will move on to testimony on the bill. Testimony can be provided in person in Carson City, via video conference in Las Vegas, or over the phone. Further instructions for providing testimony on a bill can be found on the agenda. Each person has 2 minutes to provide testimony. And first we will begin with testimony in support of AB 64 here in Carson City. Anybody like to provide testimony in support? Please approach the table and begin when you're ready.
Thank you, Madam Chair. My name is Janine Hansen. I'm the state president of Nevada Families for Freedom. We really appreciate this 3-minute time limit. I think that it's very helpful for public to be able to know in advance what's expected and what their opportunity is. My recent experience in public bodies other than the legislature is in the Elko County Commission and the Elko City Council, and there's always been a wonderful opportunity there to participate. And however, in talking to a lot of people around the state, which I did workshops around the state, 12 of them just before the legislature began, a lot of people were concerned about this issue, and they had some problems with different library boards or other things that they were concerned about. And I think to have the 3-minute time limit in the statute clarifies not only for the public body, but for the individual people that want to participate what can be expected. And so I really enjoyed the wonderful presentation about the open meeting law so that I could know more about it myself. So that was very excellent. But I think it's important for the public to know, and also that if there is a problem, they know where to go, to the Attorney General's office, or they can go to the courts. And so I think this is a very reasonable 3 minutes, and I really appreciate this particular provision being brought forward, because the public does want to participate, and the clearer it is, the better for the public body and the individual. Thank you.
Great, my first time here, so sorry I'm not aware of the procedures. Jeff Church, I run a website, watchdogjeff.com. I'm a former elected official, somewhat of a person who's been slandered and libeled, so it comes with the territory. And it's not always efficient, free speech and democratic process. It doesn't have to be speedy. But my main concern, I'm in favor of the bill overall, but my main concern is page 13, section 3, on defamation. if this passes as is, it's the end of free speech. So I'm in favor of the bill, but this...
Apologize, Mr. Church.
Yes, ma'am.
If you're testifying in support, it means you accept the bill as it is. If there are changes that you would like to make, you would have to testify in opposition.
So I don't have my hearing aids in, but
When you're testifying in support, it means that you fully support the bill as it is. If there's anything you have changes or disagreements with, that is technically opposition testimony.
okay. I'll wait then. Thank you.
Okay, thank you. Is there anyone else in Carson City wishing to testify in support? Seeing no one else approach, is there anyone in Las Vegas who wishes to testify in support of AB 64? Please begin when you're ready.
Good morning, Chair and members of the committee. My name is Nick Voskov, Nicholas Voskov. That's Nicholas. Voskov is V as in Victor, ASKOV. I'm here as a member of the Attorney General's Open Meeting Law Task Force. I also currently serve as the City Attorney for the City of Henderson. I've also been a public lawyer for more than 20 years, previously serving as City Attorney for North Las Vegas and as General Counsel for the Nevada System of Higher Education. I want to offer my support for the bill, but even more than that, I want to offer my support and thanks to the Attorney General's office for the hard work they do to organize the open meeting law task force every interim session. I think the task force is a great example of how to use the time between sessions to bring together diverse stakeholders on particular laws like the open meeting law, to discuss issues and come up with some consensus changes that that meet a diversity of perspectives. On the open meeting law task force, we have not only government officials like myself, but we have members of the press and citizen watchdogs and all kinds of groups with different perspectives. So I just wanted to offer my support for the bill and thanks to the Attorney General's office and Rosalie Bordlove in particular for her hard work. And I'm happy to answer any questions. I will say that Section 1 of the bill was primarily at my request based on my experience advising public bodies relative to the attorney-client privilege. So I'm happy to answer any questions on that if you have them.
Thank you. We don't have any questions. Is there anyone else in Las Vegas wishing to testify in support? I don't see anyone else approaching. AVH, is there anyone on the phone lines in support?
If you would like to testify in support of AB 64, please press star 9 to take your place in the queue.
Good morning. My name is Ellen Gifford. AB 64 allows the public the opportunity to provide a more complete, informative viewpoint or opinion. The 2-minute limit that currently appears to be the norm is reduced by the required speaker introductory information and any lead-in comments or statute references prior to the meaningful narrative the speaker may wish to offer. It is important that the public's voice be heard. AB 64 augments that process. Please pass this bill. Thank you.
Chair, we have no additional callers for support at this time.
Thank you. Now we will move to opposition testimony. If you would like to provide opposition testimony in Carson City, please approach and begin when you're ready.
Thank you. I apologize. I've only been here a few times before in the past. Jeff Church, watchdogjeff.com. Basically, my main concern is at page 13, section 3. If we open the floodgates to defamation lawsuits, it's the end of free speech as we know it. No person in their right mind would stand up and risk all their fortunes that they might be sued for some comment that they make off the cuff. If you do one thing, I'm going to beg you to look up Beaumont Gate corruption or City of Beaumont corruption. A watchdog individual brought corruption charges or complaints to the city. They sued him. It's called a slap action. When the smoke cleared, there were 7 indictments, 7 felony convictions of city officials. No person should be infringed from the rights of free speech, fearing that they're going to get sued and lose their fortune. Even if you win, you got to pay all the attorney fees, et cetera, et cetera. So please, don't allow this Section 3 to go in. The first time somebody gets sued for that, that's the end of free speech for anybody to stand up and risk their fortunes by voicing their free speech opinions. I'll also point out real quickly that a lot of times public comment is held at the end of the meetings. Sometimes we've had meetings that go 6 hours. That's not reasonable, in my opinion, and if you do have any discussion, you may want to bring that up. But having people sit for 6 hours of no food, no drink, not knowing, time uncertain when they get to speak is not reasonable. Thank you very much.
Good morning. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. We are testifying in opposition to AB 64 today because of Section 3, which allows public bodies to refuse public comment on contested cases until a final decision has been made, which impacts advocacy work statewide for no particular reason. There's a difference between giving a statement no weight and not permitting receipt of such comment. We look forward to working with the Attorney General's office to explore amendments that can help mitigate that risk. Thank you.
Good morning. Good morning, Chair Considine and members of the committee. My name is Randy Robinson, appearing before you today on behalf of the City of Las Vegas. We have some concerns about Section 3, the 3-minute rule. I want to make it clear, though, that as Ms. Benitez-Thompson mentioned in her opening statement, the principle of transparency is one we hold very dear. We have a very dedicated and well-experienced staff in our city clerk's office for whom transparency is a daily watchword, and they work hard to make sure that members of the public have ample opportunity to comment, to access public records, and they do bend over backwards to help the public engage. But the other thing that was interesting in Ms. Benitez-Thompson's opening statement was the principle of transparency and engagement, I think, is almost without disagreement. It's the practicalities of implementing that where discussion is generally centered. And to that point, we had the opportunity to chat with her and Ms. Bordalov the other day for quite a bit of time and asked many of the questions that some of your committee members asked. They were very gracious with their time, and we had, I thought, a very productive and insightful conversation. And we talked about the 3 minutes and how that actually works in practice for a city council. As you've experienced, pardon me, that was my timer. As you've experienced in some of your meetings already, sometimes you'll have an issue where you'll have tons of people. Other issues, there'll be almost no one here. And the way that the law currently rests, the presiding officer of that public body has the responsibility to exercise their judgment of reasonableness in helping that meeting not only stay on track, but also engage, allow for appropriate levels of public engagement. As the gentleman before me mentioned, yes, democracy is sometimes inefficient, sometimes messy, but would like to continue to work with the Attorney General's office to see how we can work on those practicalities. Thank you.
Is there anyone else in opposition who wishes to testify here in Carson City? Seeing none, is there anyone in Las Vegas who wishes to testify in opposition to AB 64? Seeing no one approach, AVH, is there anyone on the line?
To testify in opposition of AB 64, please press star 9 to take your place in the queue. Chair, we have no callers wishing to provide testimony in opposition.
Thank you, AVH. We will now move on to testimony in neutral. Is there anyone here in Carson City? Go ahead when you're ready.
Good morning, Chair and members of this esteemed committee. My name is Leah Cartwright. I'm here today in my personal capacity. I am a member of the Open Meeting Law Task Force here today in neutral. Just to let you know that this bill, we worked on it for almost a year, meeting once a month, sometimes twice a month to go over these concepts. I supported most of the concepts that are in this bill. I won't tell you which ones on the record right now that I did not support, but I do think anytime we change open meeting law, NRS 241 is already, it's a beast to read if you haven't. It's hard to get through, and any attempts at clarity that we can provide for members of the public is awesome. I would also recommend sitting on the Open Meeting Law Task Force. I've been on it since 2017, Open Meeting Law fangirl, so please join if you can.
Thank you. Is there anyone else in Carson City wishing to testify in neutral on AB 64? Seeing none, is there anyone in Las Vegas wishing to testify in neutral? Seeing no one approach the table, AVH, is there anyone on the line who wishes to testify in neutral on AB 64?
To testify in neutral for AB 64, please press star 9 to take your place in the queue.
Good morning, Chair. I actually attempted to offer testimony in support, but I had technical difficulties with my line. Would you allow testimony in support at this point?
Yes, we will. Please go ahead.
Good morning. My name is Jim DeGraffenreid, JIMDEGRAFFENREID. I am Nevada's Republican National Committee man. Also need to disclose that I am a trustee on the Gardnerville Ranchos GID, which is subject to the open meeting law. My testimony today as regards GRID is on my own behalf and not on behalf of GRID. The Republican Party supports our constitutional rights, including the right of citizens to petition their government for redress. In Nevada, we are very fortunate to have citizen access to our public bodies. The purpose of the open meeting law is to facilitate that participation. As a result, we are very much in support of AB 64 and the 3-minute time limit, because that does improve the ability of the public to participate and interact with their public bodies. Thank you.
Caller with the last 3 digits 112, please press star 6 to unmute.
Good morning. This is Bruce Parks, BRUCEPARKS. I am chairman of the Washoe County Republican Party. I am testifying in support of AB 64. It is absolutely crucial that the public be able to exercise their First Amendment right to redress their government with their grievances and speak their minds freely. Currently in Washoe County, there's a wide disparity between the amount of time allowed to give public comments between different government bodies. This is definitely a step in the right direction to improving communications between the public and their elected representatives. Again, we fully support AB 64. Thank you.
Thank you, and we will move that testimony in support. AVH, is there anyone else on the line for neutral?
Thank you, Chair. We have no additional callers on the line at this time.
Thank you. Would the presenters like to make any final remarks?
Thank you so much, Chair. Considine Teresa Benitez Thompson. For the record, I do want to ask Rosalie Bordelove to come back up, I want to make sure that, so we will continue to work with stakeholders. And my apologies in my introduction, I neglected to thank the hardworking members of the Open Meeting Law Task Force who come together and volunteer their time to talk about open meeting law. As you can see, while everyone values transparency and sunshine, the actual mechanics of it can get a little bit can be harder in application, a little bit more complicated, and there have to be more nuanced conversations. So thank you to those members who participate in those conversations with us. I think, so we'll continue to work with Randy Robinson. We'll continue to conversations with the ACLU, but I think I wanted to make sure that just so we had clarity on the record, if Rosalie, you had any, Ms. Bordelove, if you had anything more you wanted to mention on the page 11, section 3 defamation language, that we're not opening up a new kind of a whole new actions that may be brought against people when they testify in public, just so we have that clear.
Sure. Rosalie Bordelove for the record. I also want to thank all the members of the task force that have participated with us this interim and past interims. It's always very helpful to get views of across the state, as it is not just the view our office sometimes sees is what we get in complaints, as well as we represent state bodies, but it's very helpful through the task force to see how local governments and other how the open meeting law is playing out throughout the state, and that has been very valuable. For the language regarding defamation, this is language that we're mimicking language that is currently in existence in sunshine laws in other states as well, is where we got a lot of this. The goal here is to have public comment not have any special privilege, such that as over the past years, some public comment at times has gotten a little bit harsher towards sometimes public servants and non-public figures. All of you as electeds are probably aware you are public figures, case law and others. Sometimes you need to have a thick skin, and that is the case with most public body members. But there are sometimes staff members of local governments, of state government, of public staff of the public bodies who are not public figures. They're lower level staff members, and they've been subject at times to some very personal attacks. So what this change does is simply say statements you make during public comment will be treated for purposes of existing defamation law that already exists in the state of Nevada via case law and statutes. If the statements you make during public comment will be treated the same as if you made those statements on a street corner, if you made those statements in a restaurant. If an individual wanted to make a private suit for defamation, there is nothing in the open meeting law that is going to offer greater protection to statements made during public comment than they otherwise have somewhere else. So that's what this is trying to do. It does not put any duty on the public body or ability on the public body, additional ability to enforce defamation in any way, nor does it give our office the ability to, or the obligation to enforce laws regarding defamation. Those would have to be private suits. This is simply saying you don't have a special privilege to get up during public comment and make false statements about another person that you couldn't otherwise make somewhere else without being subject to liability.
Thank you so much for your time and consideration.
Thank you very much. And thank you for your service. You were the first majority leader in my first session, and I appreciate everything learned from you. Thank you. At that, I will close the hearing on AB 64. And I will now open the hearing on AB 125, which revises provisions relating to public bodies. To present this measure, we have our own Assembly Member Flanagan, and we'll just take a moment to get ready. When you are ready, please begin.
Thank you, Chair Considine and members of the committee. For the record, I am Assemblymember Tanya Flanagan, representing Assembly District 7 in Clark County. I will be presenting Assembly Bill 125, which revises provisions relating to public bodies. As you can see, the change this bill is making is quite simple. However, before I discuss the bill language, I would like to briefly review what led to this piece of legislation. No one body oversees all the operations, governance, and decisions made within this state. We as the legislature are one component of this work. At the state level alone, there are a multitude of boards and bodies that hold meetings and make decisions that impact Nevadans. On top of this, local governments and educational entities such as our cities, counties, school districts, and the Nevada system of higher education only add to this assemblage. Trying to keep track of the meetings and the work of all these entities is a daunting task and may discourage and prohibit Nevadans from keeping track of meetings and discussions. Assembly Bill 445 of the 2013 session offered a step toward addressing this issue by requiring the Department of Administration to establish and maintain a location on the official state website to post notices by public bodies that are required by the open meeting law. This bill incorporates an additional component of this requirement to further increase governmental transparency and access. This bill serves to provide concerned and engaged Nevadans with access to information in a manner that will allow individuals to be better informed and in turn hopefully more engaged in the public governing process. I know from experience of working with the current site that it can cause some frustration because it requires users to know which bodies are meeting in the upcoming 48 to 72 hours to access that information. This is because presently the website only displays the current day's calendar of scheduled meetings, abiding under open meeting law. This bill would complement AB 445 by requiring the state website to display 3 calendar days of meetings in accordance with open meeting law. By making this modification to the functionality of the website, we will better support constituents and, if desired, businesses, organizations, by allowing them to preview upcoming meetings and more conveniently participate in our open governing process. So specifically, AB 125 requires that the website location maintained by the department include a place to post a schedule of public body meetings that shows 3 days of meetings in accordance with the open meeting law, rather than a single calendar day. Thank you. I'll take any questions if you have them.
Thank you. Committee members, do we have any questions? Assemblymember Gallant.
Good morning. Thank you for this bill. So I'm curious, we have been getting a lot of emails from constituents wanting to have more notice about which, what is actually on the agenda items. So is there any intent maybe to not just post the notice that the meeting's happening, but also what will be happening during the meeting for the actual agendas?
Thank you, Assemblymember Gallant. For the record, Assemblymember Tanya Flanagan. I don't want to get the sign. What happens when you go to Nevada Public Notice is it does list the schedule of the meetings, but on that website you also are able to access the full agenda of every meeting. So it gives you everything that is there. So yes, it is already required. You're welcome.
And that is the extent of our questions. Thank you for your presentation. We will now move on to testimony. Again, testimony can be provided in person in Carson City, via video conference in Las Vegas, or over the phone. Further instructions for providing testimony on a bill can be found at the agenda. First, we will begin testimony in support here in Carson City, and please begin.
Good morning, Madam Chair, members of the committee. Paul Marashkin with the Vegas Chamber. First, Chamber would like to thank the bill sponsor for bringing this bill forward. The Chamber is in support of AB 125. AB 125, as you heard, is a good governance bill that will increase public awareness of meetings, including both state and local governments throughout the state. It achieves the intent of the original bill that was mentioned from 2013 that created the state website, and with the goal of providing greater transparency for Nevadans that want to know what's happening in state and local governments. It's also important to note that there is no fiscal impact to the state or local governments and no need for additional FTEs. Again, we appreciate the work brought forward by the bill sponsor and appreciate your support for greater transparency and accessibility throughout Nevada. Thank you very much.
Thank you, Chair and members of the committee. My name is Joe Hill, and I am a policy analyst with Retail Association of Nevada. We support AB 125 as it enhances government transparency, allowing retailers to better track policy, meetings, and other key developments, ultimately improving operations statewide. Thank you.
Good morning, Chair Considine, Vice Chair Nguyen. My name is Wesley Harper. I am the Director of Government Affairs for the City of North Las Vegas. We echo the sentiments of Mr. Marakin in the Chamber. This helps to provide a more informed and prepared electorate. Thank you for listening to our testimony and support.
Good morning, Chair Considine and members of the Government Affairs Committee. Mike Morton with the Office of the Attorney General. The Attorney General's office is a long supporter of government transparency and public participation, and therefore lend our support to AB 125. Thank you.
Good morning, Madam Chair and members of the committee. Peter Saba, SAB as in Bravo A, and I'm the Senior Government Affairs Manager for the Nevada Restaurant Association. We wholeheartedly support this bill and appreciate the Assembly member for sponsoring it and the work that Paul and the Vegas Chamber have done to put this bill forward. Thank you.
Good morning, Madam Chair, members of the committee. For the record, my name is Andrew McKay, M-A-C-K-A-Y. I'm the Executive Director of the Nevada Franchise Auto Dealers Association. Not to belabor the hearing on this, this is a good bill. It enhances transparency, as my colleague stated. I'm actually viewing this slightly in two different lenses. One is the head of a trade association that gets impacted by numerous different public bodies, but also somebody that was a public official and a regulator. As a former chairman of the Nevada Transportation Authority, the one thing you always wanted was public input, public interaction, because that's good. It results in a better end product, but I think perhaps more importantly is it improves the relationship between the regulator and the regulated entities. And this is going to do nothing but advance that cause. So, Madam Chair, thank you for your time and appreciate your support.
Good morning, Chair Considine and committee members. Lindsay Knox, KNOX with McDonald Corano. We want to thank Assemblymember Flanagan for bringing AB 125 forward. Transparency, public accessibility, and engagement are key to the accountability and success of state and local government. We look forward to the Nevada Public's website being a more useful tool for everyone. Thank you.
Good morning, Madam Chair, members of the committee. For the record, I'm Paul Enos. I'm the CEO of the Nevada Trucking Association. That's P-A-U-L-E-N-O-S. I'm here today to support Assembly Bill 125. I want to echo the comments from the previous supporters, proponents. This is good governance. It raises awareness. It raises transparency in terms of what is happening in government at all levels. And I just want to say thank you to our friends of the Las Vegas Chamber and to Assemblymember Flanagan for bringing this forward. Thank you.
Hi, Kathy Flanagan, no relation. Southern Nevada Water Authority and Las Vegas Valley Water District. We support this measure. Both agencies are committed to transparency. When we post to that state website 3 days in advance, so we support having the information made available for the public that early. Thank you.
Thank you, Madam Chair. Members of the committee, my name is Terry Graves. I'm representing the Nevada Manufacturers Association today. Not to be repetitive, we support the bill. And for business, I particularly like the local aspect of this, access to local government. Thank you.
Thank you, Chair, members of the committee. For the record, Kelly Crompton, representing the City of Las Vegas. We are also in support of the bill. We believe transparency is an important factor to what we do each and every day. This bill is enhancing the public notification process that we already publish to on the state's public notice website, and appreciate that they are keeping intact the process that we currently go through and just helping to enhance the system. Thank you.
Good morning, Madam Chair, members of the committee. My name is Tom Clark. Here on behalf of the Reno-Sparks Chamber of Commerce. Just did 2 flights of stairs, getting my steps in. Simply to say that the Reno-Sparks Chamber is very much in support of this legislation, and we are very happy that it's come forward. It's about time. Thank you.
Is there anyone in Carson City wishing to testify in support that has not done so? Okay, we will move to Las Vegas. Is there anyone in Las Vegas wishing to testify in support of AB 125? Seeing no one, we will move to AVH. Is there anyone on the line in support?
To testify in support of AB 125, please press star 9 to take your place in the queue. Caller with the last 3 digits 594, you're unmuted. Please go ahead.
Hi, this is Cameron C.H. Miller, giving great support on behalf of the Urban Chamber of Commerce for this bill, for its ability to connect our members, our business owners, to government in a more transparent and effective way. I want to thank the bill sponsor, Assemblywoman Tanya Flanagan, for bringing the bill forward, and thank you, Chair Considine, for hearing the bill. Thank you.
Chair, we have no additional callers in support at this time.
Thank you. We will now move to testimony in opposition of AB 125. Is there anyone in Carson City who would like to testify in opposition to AB 125? Seeing no one, we will move to Las Vegas, and still seeing no one approach. We will go back to AVH. Is there anyone on the lines in opposition of AB 125?
To testify in opposition of AB 125, please press star 9 to take your place in the queue. Chair, we have no callers wishing to participate in opposition at this time.
Thank you so much. We will now move on to neutral. Is there anyone in Carson City who wishing to testify in neutral on AB 125? Seeing no one and seeing no one new in Las Vegas approach. AVH, we're back to you on neutral for AB 125.
To testify in neutral for AB 125, please press star 9 to take your place in the queue. Chair, we have no callers wishing to testify in neutral at this time.
Thank you. Would the presenter like to come back and make any final remarks?
Thank you, Madam Chair. For the record, Assemblymember Tanya Flanagan. I first want to say very grateful for the support on this bill, and I urge your support for AB 125. The bill adds another layer to the transparency and centrality that will allow Nevadans to more easily monitor, track, and access the multitude of public body meetings that occur in this state, and I thank you for your consideration of this important measure.
Thank you. I will now close the hearing on AB 125. Brings us to our last item on the agenda, public comment. As a reminder, members of the public can provide public comment in person or telephonically and may submit public comment up to 24 hours after the meeting. Instructions for providing public comment can be found on the agenda. To provide public comment telephonically, dial 888-475-4499. When prompted to provide the meeting ID, enter 864-1302-9867, then press pound when prompted for a participant ID. Each person will have 2 minutes to provide testimony. Please remember to clearly state and spell your name for the record. And we will start with public comment here in Carson City.
Good morning, Chair and members. Thank you. Laura McSwain, for the record, President of the Water Fairness Coalition. It was because of AB 64 and AB 125 and the attention being given to public notice that I felt compelled to come and bring forward to you concerns that I have about NRS 237.08. It's entitled Prerequisites to Adoption of Rules by Local Government. The language that I would love to have be considered in that would be residents of the state of Nevada directly subjected to the results of rulemaking are to be included among parties to be notified by the agency seeking the change, along with and in addition to the business impact study as required. Why is this important? At the root of the open meeting process, letting people know that what's taking place is obviously relevant. The history of public meeting notices highlights their evolution as a cornerstone of transparency and public participation. Based on recent events, our statutes related to the rules-making process need some work in order for the open meeting process to be meaningful. The fundamental problem: residents who are potentially the target of a rules change are not notified directly and can be circumvented. A recent rules change sought in August of 2022 by the Las Vegas Valley Water District in Clark County illustrates the need for reform. In that example, the rules-making process included notification to 70 businesses and interested parties, yet there are approximately 360,000 residential customers who are denied direct notification. The current requirement in a rules change is to consider only business impacts. It is worth noting that the requirement for completing a business impact study were not even followed as written in this example. Bottom line, only requiring a business impact study in order to approve a rules change when anyone outside the business community is being targeted cannot possibly have been the legislative intent of the statute. And it lacks transparency. The entire point of the notification process is for the protection of the public and must be implemented with a desire for robust public participation and a goal of maintaining the public's trust. We look forward to working with the committee and other stakeholders to reestablishing this bedrock principle. Thank you for your time.
Thank you. Is there anyone else in Carson City wishing to provide public comment? Seeing none, we will move to Las Vegas. Is there anyone in Las Vegas wishing to provide public comment? Seeing no one there, AVH, is there anyone on the line for public comment?
The public line is open and working. We have no callers at this time.
Thank you very much. That ends our meeting today. The next meeting will be held on Thursday, February 27th at 8:30 a.m. here in room 4100. And that concludes our meeting today. The meeting is adjourned. Thank you. Great.